Today's webinar is all about the new Property Law Act. And I want to say this at the beginning before we get started, that the new Property Law Act was passed last year in 2023, but the actual act hasn't come into force yet. So the stuff I'm talking about today actually doesn't legally apply today, but it will soon. It was passed in about October 2023. And as what we're being told by the Law Society is that the Act will be somewhere between 6 and 12 months away from that date. So probably towards the middle to end of this year. But we wanted to get out and just talk to everyone about what the changes were so that we can start preparing for it, because it does affect, I know, well, everyone on this call, and I know your different businesses, and it will affect everyone in a different way. So I'm just sharing my screen. Can I just get a thumbs up? Trevor, you're the only one with the camera on. Can you see my screen there? Does that come up?
Yes.
Yep.
Yes.
Perfect.
Yes.
All right. So, for that, I think I know everyone on the call, but just as a little bit of background. So my name's Jeremy Stretton, if I haven't met you before. I've been a practicing lawyer for over 20 years now. It's a bit scary when you start thinking about how long you've been doing it for. And in that time, I've worked mostly in the business, property, and resumption work. So the law firm is Northern Property and Resumption Lawyers, because we wanted to focus on helping people with their property matters, and really with a big focus on resumption work. But this changes to the Property Law Act really apply to all sorts of businesses. And so that's why we sent this out. I've also written a book, if anyone didn't know that, called The Business Legal Life Cycle, all about business law and what you can do as from a legal point of view in your business, and what you should do in your business from a legal perspective. So I started NPR Law back in October 2022. And as I said, our focus is resumption work, and also helping real estate agents with their businesses. We do a lot of rent roll stuff, and we also do a lot of conveyancing, both commercial and residential. So this is all about the new act that's coming in. And welcome to the people who have just joined us. Just as you're joining us, as far as questions go, I'm happy to take questions as we're going. You can either come off mute or just put them in the chat, or there'll be an opportunity at the end to ask questions. I'll try and make this go for half an hour or so. Keep it nice and short. I know it's everyone's lunch break. I hope people are eating their lunch if they haven't had it yet. And happy to answer questions as we go. All right. So let's talk about regulation of property in Queensland. So this Property Law Act is just one of a number of different acts that are in force in Queensland that govern property law. So we have the Property Occupations Act, and that came in 2014, and it regulates real estate agents and how they sell property and how they interact with their clients. We have the Body Corporate and Community Management Act, and it really regulates strata properties and also the sale of strata properties and what you need to do there. We have the Land Title Act that regulates the title register. So every property in Queensland is put on the register, and the Land Title Act, it regulates how that system works. And then we have this Property Law Act, and the Property Law Act is really the mother of all acts to do with property. It's the main one that everything else kind of feeds on. So when they passed this act back last year, as I said, in October 2023, and for those of you who just joined, I did say at the beginning that what we're talking about today is law, but it's not actually in place yet. So we don't actually have to comply with all these rules now. That will come soon. And I mentioned this at the beginning that the Law Society are telling us probably somewhere between the mid to the end of this year is when these changes will come in. And the changes came in based on recommendations from some professors at QUT who actually, when I went through law school, they were actually my professors, and they actually literally wrote the book about property law. Like literally, I've got a textbook, and now it's going to be old when this act comes in. They literally wrote that the textbook on this stuff, and they also wrote the real estate of the REIQ draft contract. So most of you will know the REIQ contracts. These professors are the ones who actually wrote the contract and actually made all the changes and everything that was in there. The old act, and the one that is in force right now, but won't be later in this year, came in 1974. And basically the reason for these changes is that an act that old is just not fit for purpose. Coming into the 21st century, it was written before Zoom. It was written before all the electronic stuff that we all use so much today. And so what they've been doing since 1974 was amending the Act. And there were thousands of amendments trying to bring it up. And then what happened in COVID was there was a bunch of changes that happened because of COVID, that when everything changed, and the Queensland government finally decided to update the Act to bring it into the 21st century. So there are lots of changes in the Act. Most of the changes are really minor things that aren't really going to apply to anyone. So I'm not going to go through every single change because that would probably be a 2 or 3 hour webinar, and no one needs to do that. There are two big changes and that I want to go through, and some minor changes that might apply to different people. The first one is seller's disclosure. So this Act is bringing in mandatory seller's disclosure for all property in Queensland. This is super important, especially for the agents in the room today, that every property that's sold in Queensland, whether it be residential or commercial, is going to need to comply with this seller's disclosure. And I'll go through what that means. And also commercial leases. So they've changed. I know there's a few people on here who are clients of ours that we do commercial leasing with. And there's been some changes that, not massive changes, but there's been some changes in the way that we can do certain things in relation to commercial leases. And then there's some other small changes as well. So let's get into it. Let's talk about the changes. So as I said before, we're going to have mandatory seller's disclosure. So what does this mean? This means that it's going to be a new requirement on all properties sold within Queensland. There's a prescribed form for this. So there's actually a form that they've brought in, and you're going to have to attach a bunch of different documents. A bit like if anyone's done any transactions in New South Wales or Victoria, other states, or even if you've done any overseas, a lot of the rules in other jurisdictions require this. So I'm going to share what I have as a draft disclosure statement. So this is being published on the Premier's Department website as a draft disclosure statement. Now you'll see it doesn't even mention the Act, the right Act hasn't been put into this in here. And what I understand is going on, someone on the call may know even more than me if you're involved in the REIQ, but from what we understand is this form is basically being debated between the government and the REIQ and other major stakeholders about what should actually go into this form. But this is what we have as a draft, and I'm happy to provide the draft to anyone. I know a few people are already provided to, but this is the draft form. So basically, it's going to have some warnings at the beginning here, which are self-explanatory, the details of the property. It's then going to have some statements about the property. And it's going to become super crucial that our clients, especially the sellers, make sure that all of this stuff is true. And these are things that would often come up in searches that we do. Some of these things, like the dividing fences, was actually in the, or neighbourhood disputes, was actually in the REIQ contract already. So that stuff's there. But we've got to disclose all these things. Statutory and unregistered easements. This is a huge one. Most people don't realise that there could be dial before you dig type searches, easements over properties. There could be other sewerage pipes that go in different locations. If that's not disclosed in this form, which I'll get to in a moment, then the buyer can assume that that's not affecting the property. So we're going to need to make sure that we do this properly, and then we fill this form in properly. From what we've been told so far, the government is fine with real estate agents completing the form. It's just going to be making sure that we're covering off on all these things and we're asking all of these questions to make sure that none of these are issues with the property. Okay, so that's the first page of the form, pretty straightforward. The next one is the unregistered or statutory encumbrances. So those are things like the dial that you can find with the dial before you dig. There's a sewage pipe going down the back of a property. All those kind of things need to be disclosed. One very dear to my heart with the resumption is, if there's a notice from the government about any proposal about a resumption, that needs to go in there too, because obviously we don't want people buying properties that are subject to a resumption. And unless some people do it willingly, they do move into the path of an ongoing resumption. But we want to make sure that that's not going to be a problem. But then we need to actually provide these documents to the buyer as part of this form. So you'll need to have a title search. We'll need to have a registered survey plan. We'll need to have body corporate certificate, community management statement for properties that are in a body corporate. If there's exclusive use bylaws, that will need to be in there. Any of these other certificates, notice of pool safety compliance or no pool safety compliance. If there is an application, like the actual application itself, under the Neighbourhood Disputes Act, these notices under the EPA, we don't need to go into the details of those. Unlicensed building work, if there's any of those, then we need to provide this information. So a rates notice, or a statement by the seller that the lot is rates exempt, or a statement with this information in here. So this is really important that we're going to have to obtain this information at listing. I would have thought for a real estate agent, actually get the latest rates notice and provide that. The same with water. We need to provide the most recent water notice so that they can see that. Now, and then the last one is if you haven't received any notice about a resumption, then that's included as well. So all these documents are going to have to be provided, and we're going to have to make sure that we get all these from the clients. Now, this list might change as well. So I will do another one of these, and for anyone who's got a larger business who wants me to come in and talk about this stuff when we actually get the final form and how we fill it out. Happy to do that. For anyone who needs that or would like that. So that we can talk about this, and we'll talk about more when we have the final form. But we're going to have to start disclosing all of this information, and if we don't, then the buyer will actually have the right to get out of the contract. So this is going to become really super important that we start getting this information into our processes, and making sure that everything is disclosed to them and to a buyer before we actually go to contract. And then the last page is just the signer. So the seller will sign it, and then the buyer will actually acknowledge receipt by signing this as well. So as I said, this is going to be a big change, and it's going to look, when you attach all these documents, it's not going to take away the buyer's lawyer's duty to actually get in and do their searches. So we'll still have to do all these searches to verify the information, but it's really taking away that principle in Queensland property law, which was the caveat emptor, which was buyer beware. For those of you who don't know the Latin term, the Latin term buyer beware, and that's always kind of been the principle in Queensland. Now it's changing to the sellers have got to disclose all this information. And so we're going to have to get this information and provide it to them. And it's no longer buyer beware. It is that we're going to have to disclose that information. And as the lawyer, we would still do the searches to verify it, but that would be the case. So this is a big change. And I'd be interested just pausing here. Does anyone have any questions around that? You can either come off mute or you can put it in the chat. I'd love just to answer any questions around this form.
Yeah, Jeremy, if you've got me.
I do, Paul.
Hey, mate. Hey, thank you, first of all, for putting this on. We really appreciate it.
All good.
The question was specifically if you can give some feedback. I haven't come across that notice of unregistered or unlicensed building work notice. Any what there was around that, which would be pretty interesting.
And that's basically an owner builder. So it might be hard to see. I've actually got one on my desk. I'll cover the names of the client, but it's basically just a form that says that the work was done by an owner builder. Is normally what that would be. It's more a residential thing. Like you're in the commercial space, but it's more of that.
I was just thinking more around, if people have added on mezzanine and legal mezzanine, which can be a big one.
Yes, that is a big one. Yeah.
And it's hard for us sometimes to know what in areas what was the final building or not. It's all like kind of.
Yeah, and so your duty, Paul, would be to raise it with the client. We know that mezzanines often aren't approved, so it would be. I would think the best practice would be to raise that if you see a mezzanine and say, "Is that approved?" And if they're not sure, then it's incumbent upon them as the property owner to go and figure out whether or not it was approved, and then if it's not, then to actually ask the question. Does that make sense? Yep. Cool. And I'm just having a look at Andrea's thing. Yeah, it's always been around in the other states, so definitely been the case. But any other questions around the seller's disclosure?
Hi, Jeremy, can you hear me?
I can, Debbie. Good afternoon.
Yeah, sorry, I've got a sore throat. Just in relation to the commercial, like example, the mezzanine level, what if it wasn't approved? What do you do basically?
Well, then, as the buyer, you've got to make the decision about whether or not you want to require it to be approved, or whether or not you, because you're buying a property that doesn't have an approval.
Yeah.
And so what that means is that usually the local government can come in and rip it down, or order you to rip it down. They wouldn't actually come in and rip it down. They'd give you an order to actually either get it approved or do that. What we've done in the past with those is actually just go and get the approval and put that in place.
Right. Okay. Thank you.
No worries. Any other questions around that? And this is there's lots of little case-by-case things that are going to come up, especially with the new act and new disclosure rules. So that's something that if you've got questions going forward and looking at the case-by-case basis, then it's something I'd be happy to answer any questions as we're going.
Right, Jeremy, the
EPA,
the EPA one that's regarding, is that contaminated land search?
Yeah,
is that the one?
That's essentially contaminated land. So we're just making sure that that's been disclosed. Debbie?
Yeah, I was just saying with commercial and industrial, usually the purchaser will look at all their compliance, the property, like fire compliance and, all the building compliance. So there's nothing in that for commercial or industrial.
Not for that building compliance, but that would still be, like when you're a buyer, that should be the due diligence that you would put in place for the purchase anyway. So this isn't to replace due diligence. I think that's a really important part to understand. This isn't to replace it. You're still going to need to do it. It's just getting disclosed all the information that the seller has, so that when you're buying the property, you have an idea about what the position of the property is before you sign the contract. But we're still going to have to do the detailed due diligence.
The DD,
yeah.
Jeremy?
Yes, Trevor.
If there's a situation where, say, inadvertently misdisclosing something, is there a statutory time limit in which you continue to hold that liability?
Well, you hold the liability to disclose up until settlement. And in fact, if you haven't disclosed something and it materially affects the buyer, then the buyer can come after you for damages as well. So there's an obligation to disclose. If you don't disclose, then the buyer can get out of the contract, basically till settlement. This is the way that the legislation is currently written. That might change, but that's the way it's currently written. And then if settlement occurs and something's found out that would materially reduce the value of the property, then that would still be actionable as a misrepresentation. But that's very costly to go to court on that kind of thing.
Yeah, okay. Gotcha.
Yeah. Any other questions around that? No? All right. So that's the seller's disclosure. That's the big change that's come in this legislation. So just be aware of that. And as I said, watch out for the notices about when this is actually going to come into place, because it is, once it's required, we're going to have to make sure that we're putting it into all commercial sales and residential sales going forward. Andrew, if you wanted to just put your comment in there, then I'm not sure why you can't unmute. You should be able to, but maybe just put it in the chat, and I'm happy to answer that. I've got a period at the end for questions as well, so I can answer that then. So let's talk about leases. So the law around leases really is divided into two areas from a commercial leasing point of view. You've got retail shop leases, which are governed by the Retail Shop Leases Act, and there's some very finicky, a lot of people on this call who are clients of ours know, lots of finicky rules around what's a retail shop and what's not. And then the Property Law Act has always governed commercial leases. So just basic, anything that's not a residential lease or a retail shop lease is generally governed by the Property Law Act. The changes that I'm talking about are those leases. There may be some ancillary changes to the Retail Shop Leases Act. I haven't seen any yet, but they also, when they bring in legislation, they publish legislation, then they go away and they negotiate all the terms like the seller's disclosure statement, all the regulations, and then they bring in the regulations, and they have a lot of the finer details on some of these points that we'll get into. Now, as far as timing of this, so again, I know a lot of the people on the call are clients that we do leasing, commercial leasing for. Generally, when a new act comes into place, if a lease is signed before that new act, then the old law will apply. So say that this act comes into force on the 1st of July 2024, just to say that, and we sign a lease on the 30th of June 2024, generally, the old rules will apply to that lease, and anything new will any lease that's signed after the 1st of July, the new rules will apply to it. Now there can be, again, this is the transitional stuff. Well, there is more, Jared. There is more, Jared, that might apply to you. So that don't necessarily jump off straight away. Throw me off there. Yeah. So it will determine, or will be determined based on what applies from a commercial leasing perspective, and what actually the rules about timing that come into this. But let's assume for the moment that currently leases that we're doing right now, the people that we're drafting for right now, the current rules will apply. And in the future, and once this act's passed, then the new rules will apply. And we'll let you know if that changes. So the first thing is they've changed the rules around assignment of leases. So basically, this is where a tenant comes to you because they want to assign the lease. They might have sold their business, or they might not be able to meet the obligations under the lease, and so they want to assign the lease to another party. Basically, they've put in some rules around how that will work and put in a framework around the assignment of leases. First of all, lessors are going to have 1 month to consider consent. Currently, the law doesn't actually have any time frame on that consideration. Everyone that I've worked with, does it much faster than that, but you'll have a month to consider it. If you don't do it, then the tenant can actually apply to court to actually have the court order you that you consider it. And it provides that whatever the lease says about information that you need to provide. So those of you who know commercial leases will know that there's a bunch of information in there that normally you require a tenant to provide. They'll still need to provide all that information. The big change here around assignment of leases for a commercial lease. At the moment, if you've got a personal guarantee, so if the tenant's given a personal guarantee, it's very common practice to require that personal guarantee to remain whilst that lease is still in place. So if you assign if the lease is to, I don't know, Joe Bloggs Proprietary Limited, and he changes it to, Debbie Bloggs, I don't know, to Proprietary Limited, and Joe Bloggs is a guarantor under that company, then they can still be required to guarantee the lease until the end of that lease. That changed quite a while ago now for retail shops, and that's changing now for commercial leases too. So this is one of these important things that if you're a landlord, or if you've got clients who are landlords who require and like having the guarantors and keeping those people liable just in case something happens, that will no doubt apply to old leases. It will still apply, but new leases, these new rules will come in. So we're going to have to be very careful about assigning and extending leases where we want to keep people liable for this. Very important part that will need to be done. Breaches of leases. So they've really improved, I'd say, the rules around breaches of leases. So you're still going to have to give a notice. The notice will be slightly different, is what we're hearing. They haven't announced the actual form of it yet, but we'll definitely get that out once it comes out. But the breach of lease will need to be served not only on the tenant, but if there's a mortgagee of the tenant or guarantors under the lease or sublessees, it's going to have to be served on all of those people. At the moment, you can breach a tenant and the guarantors may not know about it. And this has always been one of my bugbears about guarantees is that the tenant could be in breach, and say if the guarantor has left the arrangement or is no longer involved in the business, they're still bound by the guarantee, and then they may not know that the tenant's actually in breach, and they could find out years down the track sometimes that would be the case. So you've got to serve the notice of breach of lease on the guarantor and any sublessees, and any of them can apply for relief to say that you can't take the property. Now, what the reasons for that will be, but that will have to be decided by the case law. Normally, if a tenant hasn't paid their rent, which let's face it, is the normal reason why we would serve a breach of lease, then it's going to be very hard for a court to say that you can't do that because someone else says so. But there might be other remedies that they look at as well for there. So you've got to give them all that information. Another big change around this is around if the tenant has vacated the premises. Everyone on here who I work with has had the situation, I'm sure, where the tenant has just packed up their stuff and left. We saw that a lot during COVID, unfortunately. And there was always this thing about, well, if the tenants abandoned the premises, if they've left and pulled out all their stuff and walked out of the premises and you can't find them, then how do you serve the notice on them? It was always been a difficulty. I know people on this call who we've had that conversation with. Well, this is now changing. That if you reasonably believe the tenant has left the premises, then you don't have to give notices. You can just go in and change the locks, which makes things a heck of a lot more practical in that situation. So we want to make sure that that if that happens, that we're not having to serve the notices and not having to go to that expense. Because that's another thing too. Like it's an expensive process to serve the notice or to draft the notice, to then go and serve the notice personally, try and find the person, all the rest of that. So that's a very sensible change that will help us, landlords to be able to enforce our leases. And the third major change for commercial leases is just around lease renewals. They've actually beefed up the rules around when a lessor can refuse to renew a lease because of a breach. So that's been pretty loose over the years. I say they've beefed it up. This is one of the things where they've changed the wording that makes it seem like it's stronger for a landlord to be able to do this. We're going to have to see that on a case-by-case basis and see how that applies. But sometimes we have landlords who don't want to agree to an extension of lease because if the tenant's been chronically late the whole lease term, and then they bring it all up to speed, on the 3-year lease, and they bring it all up to speed after 2 years and 9 months. Currently it's very hard to still say no to that. They're changing the circumstances where you can refuse that. So that will be a case-by-case basis, but it's something that we'll be able to do going forward. Andrew said, brilliant change for assignment of lease. It is necessary to put time frame around reasonable. So it is necessary, and the reasonable time will really depend on the circumstances. So generally, at most 14 days is considered reasonable in most circumstances. But things like where someone's abandoned premises, that will often be a much shorter period of time, or where they're in breach of a lease because they've constructed something that is in breach of the lease or causing you problems. Then they're all different standards, but we don't want to have a minimum time frame or a maximum time frame in the legislation, because that constrains us to what we do. So I think it is necessary to put a time frame, but it's very much dependent on the circumstances. Okay, no worries, Sasha. We'll provide the recording as well. No problem at all. All right, so the other changes. I'll come to questions about if you've got questions about these changes or leases or anything else. I'll get to that shortly. So let's talk about the 3 other major changes that are coming in. As I said, there's lots of little small changes, but these ones are important. So next one is deeds. So a deed is a document that gets signed and no money actually changes hands. And for years, and in fact in the old Property Law Act, you had to do that in person. Had to be signed in person. And a lot of stuff has changed in COVID. This has been, I think, one of the great innovations, and most things can now be signed in Adobe Sign or any of those other things. And so what we want to do is just make sure that we're getting it signed properly electronically. There's an electronic record of everything. Guarantees and indemnities can be signed electronically as well. So these were rules that were brought in for COVID that have now been made permanent as part of the permanent changes. Paul, did you have a question? Oh,
sorry, no.
Sorry, I thought you had to ask a question. And the other one, this is a small one, is so with a deed, with an agreement, you used to have 12 years to sue someone if they breached it. Now you have 6 years. Next one is easements. So the easements are something on the property that that allows like access. You might have an access easement where you have a access to get to a property behind property. The way that the law currently works with easements is that in some situations they weren't actually binding on people who bought property 2 or 3 times down the track. Now the law's been changed to be that it 100% is an easement, and it will bind all parties. So that's a good change. And the last one, and this applies to residential and commercial contracts, so thank you for staying on, Jared, is about installment contracts. So the law under the Property Law Act used to talk about installment contracts, and it was pretty, what's the best word? It was pretty vague as to what an installment contract was. This language is now being beefed up. So the reason why we don't ask for more than a 10% deposit in Queensland is because the contract becomes an installment contract. That's for a existing property. If you're doing an off the plan contract, it's a 20% deposit. There's also so that was pretty clear. There was always this question about if you made a non-refundable deposit under a contract, whether or not that made it an installment contract. My view was always that it was. So it was an installment contract. And so my advice, especially to agents and all that, was not to ever have a non-refundable deposit unless you were willing to go through that process and make and have it as an installment contract where you would have to provide 30 days extra notice if they weren't able to settle and all those things. That's now being clearer defined to be the case. So if you have a payment under a contract that it was more than 10% for an existing property or 20%, or is not a deposit. So if it's non-refundable, then the contract becomes a installment contract, and there will be there's a bunch of rights that gives the buyer. Depending on how much that you transfer, they can actually require, or how much of the percentage of the price that they pay, they can actually require the land to be transferred to them, and the seller takes a mortgage over the property. They can put a caveat on the property, which can cause all sorts of problems. They can do all sorts of things with the property by being an installment contract. So this is a really important change, because I know that sometimes sellers, they want to put clauses in contracts to try and make sure that they're not stopped from doing or their time wasted on contracts by speculators, especially as the market might fall a little bit. More of that might start happening. If we have something that's not a refundable deposit, then it will be an installment contract. So it's something that we really need to be wary of and make sure that we don't go through. So everyone, that is the main changes to the Property Law Act. If you want me I'll invite it. Once the laws actually come out and we know a start date, we'll be back in touch to do another talk and to clarify exactly what the changes are and what needs to happen. If you're interested in having us actually come and do a talk, let me know. You can either email haley@nprlaw.com.au, or if most of you know me directly, you can just message me. We'd love to do that. Make sure that we're all on top of this stuff. Any questions from anyone? I know we kind of ask questions as we're going, but anyone got any other questions for me today?
Yep, Jeremy. On the leases, on the breaches of leases, common ones, especially in property management, asset management. So the breach will have to get sent to the guarantor 100% and every other person or part of the lease. So every other the director part of the tenant. Is that correct?
Say that again, Paul. You broke up on
on the breach, you're saying it to be sent to the guarantor plus all the other parties on the lease, like the relevant directors of the tenant as well. So
only the guarantors. So it just needs to be sent to the company and then the guarantors. It doesn't say the directors of the
company and then the guarantors. Okay.
Yes. Yeah. So if you have 5 directors and one's given a guarantee, I know that's not an unusual case. You only have to send it to the company and the guarantor. You don't have to send it to all the other directors.
Yeah.
But you would hope that someone who's a director of a company would be on top of these things.
And have you got any feel for what the timing may change for that around from what the current timing is on sending a notice to remedy breach? And that?
I don't think that's going to change, Paul. My reading of it is that the actual timeframes won't change. It's just who you've got to send it to.
Okay.
Like the standard, the standard rules are 14 days for non-payment of rent, and for other things that are more urgent, it's less time than that. So it's really a case-by-case basis, but that requirement isn't changing as far as I can see.
Okay.
And Dugan Cove asked, do we still need wet signatures? Yes, at the moment, to register a lease on title, we have to have an original signed document. So that might change. That's actually the Land Title Act. I went through all of those those different legislations at the beginning, but the Land Title Act is the one that governs that. That's not been changed, and at the moment we still need that. So one of the annoying things that we have to do is when we're getting say an extension of lease signed, we need to we can't do that electronically if the parties want to get that registered with the titles office. So we'll still need that for the time being. Hopefully that will change. It seems sensible, but it would make it a lot easier. And Andrea, having directors in Sweden does make life hard. Other questions?
Oh, I just have one, sorry. Just in relation to like the assignment of lease, if it's an older lease, usually there's a clause in the lease that actually says that this sign all is always basically on the book.
Yep.
So when the new rules come in, here we go. Are we going to just ignore the new rule because it's in the current lease, which is older?
Yep. So this is what I was saying before around transitional provisions, and it's something that hasn't been released yet. So normally the case that the law would be that it's changed and old leases, the old rules apply to. So you can do that. That's fine.
Yeah.
And new leases it wouldn't apply to. And this will become an important distinction for landlords to decide whether or not they want to just do a brand new lease or do an extension of lease, right? Normally that's the case. They have in the past changed laws retrospectively like that, where they've said, okay, well now no one else can have that type of clause on there. So at the moment, it should be old leases are fine to continue, but we don't know until it actually changes it.
Thank you.
No worries. Other questions?
I have got off mute.
Hello, Andrea. Good to hear. How are you?
Hello. Good. I think these changes, I mean, it scares me how onerous some of them will be, but they just make sense. And from a practical point of view, and coming originally from Victoria, 15 to 17 years ago, one of the first things I said was, where's the section 32 or the section 52? And went, what are you talking about? Buyer beware.
Yeah.
So it's really interesting. But, there are a lot of good examples where a landlord, unfortunately, the agent often, I'm sorry to say that to agents or solicitors, whoever it is, take 1 to 3 months to decide whether they approve an incoming tenant.
Yeah.
So that's difficult. It's not always on the landlord. There's my comments. I have some really good thoughts around mould, and anyone who wants to engage with me on that at some point. I've drafted a mould clause that I'm trying to get recognised because personally I have a mould-related disease. So I do understand how actually toxic it is. And yet in a commercial lease, an RSL, a residential, nobody wants to touch it and say, this is the process for mould. So just thoughts for everyone, wherever you're coming from, whatever your occupation is here, it's a good thing to have a process, and then you avoid dispute.
Yeah, 100%. And that's why, all these things need to be considered well and put into the lease in a way that will protect both sides and actually give, like a lease.
Absolutely.
The document of a lease is like any contract. Yeah, good contracts make great relationships. And so if you're concerned about something, having a clause in there that will actually help to assuage any of those fears will actually help you a lot. I think
everyone should be concerned about it because we're in Queensland, number one. We've got increasing severe weather events, number two. It's just commercially smart.
Yeah,
that's all.
100%. All right, thanks, Andrew. Any other thoughts? Any other questions? All right, well, thank you, everyone. And we'll be in touch once we know more about when the actual act is coming out. Really thank you for taking the time to listen to this today. And we'll be in touch once we know more about the changes so that we can make sure everyone gets it in there. Thanks, everyone. Have a great day.
Fantastic session. Thank you.
No worries. Bye. Bye, everyone.